we've got a couple of questions that have dropped in from the audience. And Paul, this one dropped in during your segment, and it's what constitutes a verifiable request from a customer when talking about sort of businesses covered under the CCPA, and who would determine whether or not the request was verifiable or not? And if it was deemed not verifiable, would the customer have any sort of recourse if that wasn't the case?
Fantastic question, and one that I think is very predictable. I'd be interested to hear if Rebecca has any feedback on this, but my look at the statute is that verifiable request is not clearly defined and is likely to, if at all, to be defined. Well, it hopefully will be defined by the California Attorney General in the rulemaking process. Alternatively, and probably in a less satisfying manner, it could be defined by the courts. So once it is defined, hopefully by the California Attorney General, then it would be up to the company receiving the request to evaluate whether or not the consumer making the request or the request made by the consumer constitutes a verifiable request. And if the company decides that it's not a verifiable request, but the consumer believes that it is, interesting and unstated question right now, or unstated answer right now as to what happens. I imagine that the consumer could complain to the Attorney General, who, if the Attorney General is satisfied and interested, could bring a complaint against the company. Rebecca, do you see it any differently than that?
I don't, and I think that's one of the areas where, really we need Javier Becerra to provide some more clarity to businesses. I think one thing that comes to mind is, a number of companies for compliance with the GDPR have allowed, or for requests made pursuant to the GDPR, which has some similar disclosures of personal information collected and deletion rights for consumers. Those companies will often use a password protected login. So if you are a consumer who has an account with the company and submit a request through a particular portal with the password that the company has that you previously provided, that's a way that companies have verified those requests under the GDPR in Europe. Again, I think there's going to be some questions about what is necessary to verify that consumer request, particularly because the CCPA applies for businesses that don't directly collect information from consumers. So hopefully Javier Becerra will provide us some much needed insight there.
Excellent. And one final question here. Rebecca, this did drop in during your segment, but Paul, I'd love to hear your insight as well. What are some upcoming areas that the California Attorney General may focus on in the rulemaking process and in upcoming public meetings?
Well, great question. We just talked about one, the verifiable request and what is required for determining that. The statute itself outlines certain things that the California Attorney General needs to address in the rulemaking process. Some of these, it's interesting because some of these are forward-looking and some of these are based in the present. So some forward-looking things are, the Attorney General has the ability to update categories of personal information to address changes in technology, data, and collection practices, and other privacy concerns. Really, that means, if anything, the definition of personal information could get broader. The California Attorney General also has the ability in the future to update the definition of unique identifiers and methods for submitting requests under the statute, as we just talked about. There also might be, it's interesting because the statute says that Attorney General Becerra has the ability to establish exceptions when necessary to comply with state or federal law, but the statute itself says that it preempts all lower laws. So it's unclear what the legislature is intending to get at there. I think Javier Becerra will also address rules and procedures to govern opt-out requests, which will hopefully give businesses more clarity in what they need to do to comply with consumers' right to opt out. He'll also be implementing rules and procedures to clarify what the notice requirements are and disclosure requirements. And it's also possible that Attorney General Becerra will be increasing the monetary threshold or changing the monetary threshold for a business to come within the CCPA's purview. I think those are things that are expressed in the statute. I think we might also expect Attorney General Becerra to look at, for example, the definition of service provider and a third party, and hopefully clarify that the act isn't intended to impose secondary liability, and that the Attorney General enforcement would be more limited to its consumer-facing aspects of the statute. And I would expect that companies will be submitting requests for comment or input along those lines in the upcoming meeting.